Okay, we are now on record, and this is a deliberation being held before the Baltimore County Board of Appeals, and today is February 25th, 2025. It's 9:30 a.m., and this is regarding the Friends of Lubavitch legal owner, case number 2024-0112-SPHXA, and the petitioner is Friends of Lubavitch, and were represented at the hearing by their counsel, Mr. Lafyandra, and is appeal of a decision issued by order of ALJ Murphy involving property located at 14 Agworth Road in Towson, Maryland. It was a de novo hearing that was held before our board on January 14th, 2025, and the closing memo was received on February 14th, 2025. And the petitioner requests that the board reverses the ALJ's decision and grant relief sought in the original petition, which would allow them to continue their religious activities on this property. And there were numerous issues raised, so I asked my co-panelists who joined me this morning, Mr. Evans and Mr. Lauer, to bear with me. I do want to give some background for the record, and then how I would like to proceed, unless you would like to proceed differently, is to go through, identify, they're like 8 separate issues, and I can just go through my review, and then each of you could do the same on the issues that I raised and any that I may have not raised that you identified during our hearing.
Okay.
Okay, great. That's how I'll proceed then.
Thank you.
Thank you. Just some background. The petitioner is as the legal owner of this parcel, which is 17,000 square feet in Towson area, and it's right across from the Towson University campus. It is improved by a 3-story brick and stone building that was originally constructed in 1952, but there was a substantial addition in 2016, and it is zoned DR 5.5, and the petitioner noted in their memo and at the hearing that they are seeking the following: approval of the use of the existing structure as a Jewish center, Jewish learning center styled as a Chabad house, and they seek that approval by use by right under BCZR section 1B01.1.A3 as a religious institution permitted in the DR zone. They also then alternatively seek a special exception under BCZR section 1B01.1.C4 for the use as a, quote, civil, social, recreational, educational use permitted in that zone. They further seek an exemption from the RTA regs pursuant to the cited reg. It's 1B01.1.B.1.G6 as a new church or other building for religious worship. Then have, again, an alternative exemption under RTA pursuant to that same reg section .G10 as a structure devoted to civic, social, recreational, fraternal, or educational activity. They also seek a modified parking plan under Baltimore County Zone Regulation 409.12.B to permit 2 parking spaces in lieu of the otherwise required 23. They seek variance under the regulation cited for existing interior side yard setbacks, and they're requesting 8 and 13 feet instead of required 20 feet. And from that same section 301.1 for an existing carport side yard setback, 7 feet instead of 15 feet. And they note that there's no new construction as proposed. They summarized their arguments and stated that they provided evidence that demonstrated that the proposed use is consistent with applicable zoning regs, either as a matter of right or through grant of the special exemptions requested, and would be compatible with, let me find my spot, with the character and general welfare of the surrounding residential premises. They also say that the site plan maintains the RTA use requirements to the extent possible, and they claim that the parking demand would be minimal and that the property has unique characteristics and the petitioner would experience practical difficulty if the setback variances were not granted. And they then further proposed the use will address a critical need for religious and educational services for students and community members in the Towson area. There is some history with this property that was noted during the hearing. There were 3 past zoning cases, 2015-0223-SPH, also 2016-0170-SPH, and 2016-0308-SPH. Of 2015 0223 SPH, so it was filed in 2014, involved requests for a special hearing to confirm the continued use of the property as a residential parsonage with an accessory for use for religious worship and religious education. And the ALJ denied the request, finding that the structure did not qualify as a parsonage because there was no synagogue to which the parsonage was pertinent. In 2016 was case regarded a special hearing that was voluntarily dismissed by the petitioner at the appeals level. And then the 2016 case was initiated by neighboring property owners. It was dismissed by prejudice by the ALJ, went on appeal to the board. The board later stated there was credible evidence that the site had been used as a dwelling and a community center, requiring a special exemption and compliance with the RTA requirements. In this current case, the petitioners are, the current use of the property in this case is that of a Chabad house with an accessory parsonage used for resident rabbi and family for the petition that was filed, and they claim that no improvements or alterations are being imposed on the interior or exterior of the property, and that the 2024 site plan mirrors that of the earlier site plans. We did admit expert J. Scott Dallas, who prepared the site plan, and he was admitted as an expert surveyor and expert in zoning and BCZR regulations. So thanks for allowing me to go through that summary, because I do believe is pertinent to the numerous questions that are before us. And I do want to commend the petitioner on their memo and how they laid out the questions, and I will go in that order. The first that I have is whether a Chabad house is a religious institution as referenced in BCZR section 1B01.1.83, and if yes, then it would be permitted by use by right, but if not, then we would have to consider whether or not there's a special exemption required. And I found that it was not, didn't meet the definition under the regulation for different, several reasons. One, I noted that Rabbi Rivkin, who of course is learned and has knowledge of religious, Jewish specifically, on religious practices, but he was not admitted as an expert on these practices. But he did offer testimony to the activities on the property. He argued and stated in their memo that the term religious institution, well, while not explicitly defined in the regulations, must be interpreted, quote, in light of its common and ordinary meaning, rendering the nature of the activities of the property supportive of their position that it's a Chabad house and that a Chabad house is a religious institution, which in turn should be permitted by right. But petitioners offered Mr. Dallas, as they noted in page 6 of their memo, that he testified and gave professional opinion based on his observations and evidence presented that the Chabad house on the property constitutes a religious institution within the meaning of the regs. My concern is that Mr. Dallas, although he's an expert, as we admitted in surveying and zoning regs, is not an expert. To my knowledge, at least he didn't assert he was, and we didn't admit him as an expert in Jewish or religious practices. And he actually testified that he did not observe any religious services on the property, that he viewed very little activity during his visits to the property, but relied on information provided by the petitioner and what he found on the internet. And so I don't believe that that would allow his opinion on this issue. It's not persuasive for me, and that it should be limited to the zoning, other zoning questions, and the BCZR regulations. Also, ALJ Murphy noted in her memo on page 8 that ALJ Burvagen in the 2015 matter relied on the testimony of Rabbi Rivkin, wherein the rabbi stated that the property was not used as a synagogue, and finding that a synagogue was required for the property to be used as a parsonage, to allow parsonage on the property because it had to be adjacent to the religious institution, which would be the synagogue. But in that case, the petitioners also contested a citation that was issued, I believe it's March of 2015, for failing to cease the legal operation of a house of worship or religious institution. And their defense led ALJ Burvagen to approve the residential expansion and deny that parsonage. Now the petitioners are testifying that services are held at the property. I believe that even if such services are held, that other requirements must be met for the property to be deemed a religious institution under regulation they cited. So I therefore don't find that under the initial question that there is a permitted right under BCZR section 1B01.1.1.A.3, and wanted to hear both of your thoughts on that issue.
Mr. Loudon?
Well,
Or anything to add to what?
I think, well, let me just, a couple things here, just going through my head. I think the parsonage and synagogue is a different kind of argument in my mind than the Chabad house. That's kind of how I see it. And my instincts in terms of the testimony that was given, and reading the memo, etc., is that this Chabad house is for religious purposes, at least we could say. And I don't know if it's semantics or whatever, but it seems to me that it is a religious purposes at least. And maybe we're looking at the difference between purpose and institution, and I don't know. And I would, we're here to deliberate and get your thoughts on that, Mr. Evans. Maybe you can help us.
Well,
Handle many of these in your time, I think.
well, I do agree that Scott Dallas was a exceedingly profoundly weak witness with regard to all matters of Jewish tradition and religion. That he's not Jewish. Okay, he got his information off the internet. I mean, really that's very unconvincing from the point of view of the legalisms associated with expert witnesses. If there'd been anyone here that really bothered to contest it, I think he would have not been permitted to testify to that stuff. Having said that, I think it is absolutely the case that a Chabad house is a religious institution, and I don't know that it. I think we can almost take note of that as a matter of judicial notice, so to speak, because well, just honestly because it is, and I think it is. I would rule that it is undoubtedly a religious institution, and actually, there was this federal litigation that under our LUPA, that presupposes a religious institution or the practice of religious views.
Yeah.
So, I mean, I just sort of think, I would rule that this is a religious institution. I wouldn't have any real hesitation on that.
Thank you, sure.
There's a
And
whole
I'll
lot of-
definitely get to Relupa. So, so then we can agree that it is a religious institution under the regulation that's cited.
I think
I
so.
would, I would also agree, yes.
And so then they had a second question that they should be approved under a special exemption as a civil, social, or recreational purpose under .C4 of that same regulation. And I had, similar comments that around Mr. Dallas and his testimony and whether or not he should be, used as a witness for those purposes. And so then
I would agree with you, Madam Chair, about that, but I don't think we necessarily need to go there. I believe it's an alternative argument. If we agree that this is a religious institution, then I think in a DR, what is it, DR 35?
yes.
Yeah, in that district that they are permitted. So I don't think we need to look at the special exception if I'm reading it correctly.
Yeah, I agree with that.
Correct.
I agree with that. Yeah.
Same here. Just wanted to go through all the things that they raised.
Thank you.
And then they had whether the RTA does not apply. We need to determine whether it does not apply. And if it does apply, whether the Chabad house is exempt. And ALJ Murphy in previous cases before this board as well, I mean, specifically the 2016 matter, said that the RTA applied to the expansion that was taking place at that time. The petitioners argue that there isn't any current expansion proposed, which is correct because the expansion already took place. But I guess the question is, do you get to ignore that an original RTA requirement because the petitioners, ignored that requirement at the time of the earlier proceedings. And I agree with ALJ Murphy. I know it's de novo, but I feel that the RTA was applicable to the Chabad house in this zone. Of course, I'm not going to the Arlupa portion. I'm going to get to that later, but just on the merits of the regulation or the requirements of the regulation itself, and wanted to see if we agreed.
I agree. I think the RTA applies. I'm not sure that in the 2016 case, we didn't really argue that. It wasn't really argued on the merits. It was just assumed that it applied. But I think that assumption was correct, and I think it does apply.
I agree also.
Great, realign there. And then we would go on to the parking modification plan. I found that the described activities, the volume of participants, but potentially as the third party who testified, raised, as well as Rabbi Rivkin's testimony, that participants extend beyond the Towson student community, but the greater community as well, that where it's located, it could create issues for parking, and I don't believe you can rely that everyone will always walk and carpool to the Chabad house. And so for those reasons that were provided, I didn't think that they met that burden. So I didn't think that there should be a modification granted for the parking.
So, just to be clear, so you wouldn't grant the variance for the parking from 23, I believe it was, to 2?
To two, I would not.
Yeah. Yeah. Well, I have problems with that also. They talked about, I think that it's Towson students, and they also mentioned Goucher students, and they also mentioned other persons. And the services are not just on Friday, but they do have some during the week, and they also have some obviously on Saturday services. So I think the impact of the number of people who may be using this facility on the community, it is going to be substantial, is now substantial, and is going to be substantial. But the variance from 23 to 2 seems like a pretty big gap here. I know that they said they had additional parking on the neighboring property, I believe at 12, as opposed to there at 14. But that wasn't, it isn't leased out for them for that period of time, and seems to be on an ad hoc basis, as far as I could tell. So I do have some issues related to the parking also in this proposal.
Right, so the parking issues are from Friday night sundown to Saturday night sundown.
Right.
That's when driving is either prohibited or limited. And we've taken note of that in a lot of other Orthodox cases occurring over in the Green Spring area mostly. But like the two of you, I also believe that the parking issue is not something that is ameliorated just because there's a 24-hour period where there's walking. I mean, the Chabad house is an activity that is ongoing 7 days a week, 24 hours a day, and there are 6 days a week when there is driving, and that's a neighborhood with limited parking. I think there's permit parking is for neighbors, Anyway, it's not a place that can, where under the zoning regs, we can dispense with reasonable parking requirements. So I agree that the question of the variance from parking is not proven.
Yeah, and you don't create the thing and then call it a hardship,
Well, there is that too.
Yeah, I
Yeah,
mean,
this is the ultimate self-created hardship.
yes, I see that, and that you create it and then you say, well, we need more parking, but yet we have the facility here and, I just have similar problems with the parking situation and the drop off also, there on the street, which was talked about, I think, in the testimony, before us.
Correct, because I think Ubering was offered as a solution, and that's where the congestion issue was raised. So we align on the parking variance matter, and for the same reasons, I would say the side yard variance. The hardship is created by the addition, the expansion to the original property, and as Cromwell, that practical difficulty or unnecessary hardship for zoning versus purposes should not be self-inflicted. And ALJ Murphy also offered, I believe it was Add Soil in Chelsea, as other cases that support that same position.
Agreed.
Agreed.
So then on the race judicata collateral estoppel piece, I know petitioners, they cited a case that was more recent than the case cited by ALJ Murphy, and the issue though remained the same, and is whether or not the original issue that was actually litigated previously is being relitigated in this matter. And this came out somewhat during the hearing, is that it's tricky in that the petitioner seems to be arguing the counter opposite of what was previously argued. And in doing that, does that mean it's not the same issue? I personally feel that you should not get a second bite at the apple by taking a counter position. And to quote ALJ Murphy, and her characterization was a little more harsh than maybe I would use, but I mean, she said, quote, petitioner deceitfully changed their narratives about the actual use and their site plans to suit whatever litigation is pending. And I do believe that by allowing that, it would actually mock the whole doctrine of collateral estoppel. And so I think there's an argument that is the same issue. Whether you took a different position doesn't mean that the issue changed. And so I believe that for those reasons, they would be collaterally estopped.
I also would agree, and I think there was testimony related to, are you basically doing the same thing? And the answer was yes, as I recall. I don't have the lines in front of me, but my recollection is that basically they've been doing the same thing for a number of years here through the period of time. And if you're doing the same thing, if you call it whatever you call it, whether you call it a synagogue or then get into that parsonage argument, or you come up to the Chabad house and get there, if you're doing the same thing, the same services, it seems to me that the principle of res judicata and collateral estoppel would apply.
I agree.
Thank you, Ray. I think they have the same signage from the previous hearings as well, and that was noted and in prior cases and the cases on appeal. So as you mentioned, Mr. Lauer, there hasn't been any change in the use. Then we have to now go to the issue of our LUPA, as you mentioned, Mr. Evans. Even if they were stopped and they didn't meet the burdens of the several of the other issues presented, except for the initial one, under our LUPA, the Religious Land Use and Institutionalized Persons Act, as discussed on the memos, pages 18 through 20, then we are determined for leave should be granted for the reasons that our LUPA provides. And just to highlight the ones asserted by the petitioners, that no government shall impose or implement a land use regulation in a manner that imposes a substantial burden on the religious exercise of a person, including a religious assembly or institution, unless the government demonstrates that imposition of the burden on that person, assembly, or institution. And they also highlighted that the subsection applies in any case in which the substantial burden is imposed on the implementation of a land use regulation or system of land use regulations under which a government makes or has in place formal or informal procedures or practices that permit the government to make individualized assessments of the proposed uses of the property involved. And the government has a discretion of alleviating its burdens on the religious exercise, and we're to avoid preemptive force of any provision of the chapter by changing the policy or practice that results in substantial burden on that religious exercise. And wanted us to have a discussion there. I believe that the petitioner's argument that the board has discretion to eliminate the substantial burden, and they quoted by any means necessary at page 21 of their memo, and they cited Fourth Circuit cases, including Bethel and JCIAM, in support of their position that where our county regs, zoning regs permit by right the use of the DR zone land for houses of worship and provide exemptions to the RTA. And there's done in broad permissive terms, and that there's a quote reasonable expectation to acquire the approvals, and that denial of those approvals would result in a substantial burden to the petitioners. And I fully agree with their arguments under our LUPA.
Well, I also fully agree with their arguments under our LUPA, though in a rational world, I wouldn't. Frankly, the Friends of Lubavitch in this matter have acted with the most unclean hands imaginable. They have denied doing what everyone knew they were doing, and now they want permission to do what they denied doing. Okay, number one. I heard Rabbi Rifkin 8 years ago. The circuit court heard him 8 years ago. He was not a credible witness. The building was built without permission. The building was built with a fraudulently obtained building permit. Okay? It was ordered to be torn down by the circuit court, and that was affirmed up the ladder by the Maryland courts. Okay? Mr. Dallas testified in all of these things, and frankly, I remember his testimony from 8 years ago, and it was not credible then. And frankly, that bears on my view now of his testimony. All of the testimony is coy, it is insincere, it is misleading. And I don't know, I wouldn't call it perjurious, but it certainly is nothing that I would ever accept, frankly. Okay. But we also have now at least 10 years of experience with our LUPA. And what we've learned is that the county, I don't know if it's fair to blame the county attorney's office or the federal courts or something, I'm not sure what, but it's all sort of irrational to me. Okay. But the simple fact of the matter is that if we deny this, it's going to cost the county $2 million probably by the time the dust settles, and everything that they want to do will be ordered to be done. Okay. So if we deny this, all we're doing is penalizing the taxpayers of Baltimore County. So as much as I think that the Friends of Lubavitch should do some real honest to God soul searching over their behavior in this case, I would grant all of the relief requested, and I would grant it solely and simply because of our LUPA. And then that would just be the end of it for me. I'm not happy about it, as you can tell, quite unhappy about it. But I think that's the right result. And I think that I think we've been, not just in this case, but in any number of cases, the county and the zoning authorities have been bullied into untenable positions, and that's life in the fast lane. Okay, so in my view, that's where we are. Everything, I mean, I would agree that it's a religious institution. I would deny every other zoning relief. I would affirm based on res judicata and collateral estoppel, but at the end of the day, I would grant the relief for the reasons I said. And end of Joe's rant.
Mr. Evans, I know that you're very much more familiar with the federal law and the situation than I am. But does it make a difference that this would apply also to other civic or social or other type of uses? If this had been, I don't know, a Lions Club that came in, I'm just coming up, rather than this, I think we would have been at the same place in terms of all of the issues for parking, for side yard variance, res judicata. We would have been at the same place, I think, in
Right.
terms of denying it.
Mhm,
Right.
mhm, correct.
Right.
So doesn't that make a difference in terms of whether to apply the federal law or not?
Well, this is religious, and the Lions
I
Club is not.
understand that. I'm saying but
And the
if it
laws-
were
the
a
laws-
non-religious type of situation, we would have said this. And we're saying because it's a religious situation, we're saying this, but we can't really say that because it's a religious institution. Is that basically where we are?
I
It
think that's
preempts it.
exactly where we are. Yeah.
Yeah,
And I think that's what the law is,
Yeah.
or argue that. I mean, maybe if, maybe there are defenses to the application of the Arlupa provisions. Maybe there are defenses that could be litigated in federal court. Okay. But I have no idea how they would end up. And I can guarantee you, I'm as certain as God made little green apples that the county would settle. County wouldn't risk litigating this. Okay.
because of the past.
They wouldn't risk having to pay attorney's fees to the petitioner, and they would pay them money Okay, and then they would say, okay, you can do everything you've always wanted to do, everything you denied doing, but you're doing. You can do it all, and you can do it all lawfully. And who cares what the Board of Appeals or Judge Murphy said, or, anything. Okay, so I'm just jumping to the bottom line.
I, I agree with you,
That's
Mr.
a very
Evans.
cynical view on my part, but I'm jumping to the bottom line. I don't think we have any choice, actually.
I mean, there definitely
Any
has been
authentic choice,
there definitely has been bad faith. We've had other cases wherein the religious communities have worked with their neighbors in order to move forward with various plans, and the opposite has been here. And the petitioners referenced the previous settlement with the county, and even noted in that settlement that they would be granted this relief. So I'm with you, Mr. Evans. Why should they be, my opinion, unjustly enriched in essence, for their behavior, when ultimately it's going to result in them being able to continue to operate the property as it always has been? I think the most we can do is, as ALJ Murphy did in her opinion, is note the concerns around the behavior and the lack of cooperation, the incredulous testimony. I believe that at the hearing, we even noted that Mr. Dallas arguably has a professional responsibility to, of course, testify, but also file site plans and report to the county of what's actually happening, not that he's required to do by his client. And he said that he testified that he just acts on behalf of his client. And I would argue that when you are certified and licensed to do certain things as a professional, you have to act as a professional and not just do the will of who pays your bills. So I do think that we should strongly, in the opinion, note why we reached the conclusion that we reached, and at least that would be a matter of record for if there are ever challenges in the future, or any amendments to any federal acts, because it should be taken into account, I believe, the activities of the petitioner.
Yeah, I oftentimes disagree with Judge Murphy I thought that the opinion that she wrote was just spot on and was well done, really, really, really well done and well crafted. The one advantage she had is she had us. Okay. She didn't have to deal with our LUPA, and because we do. And I that's I mean, I feel as though we have to reverse her decision, but I imagine she saw that coming, and she saw it coming for the reasons that we've given. And I wanted to just take a moment, because I have been critical of her in the past, to just note what an absolutely excellent opinion I thought she had written. But nonetheless, I would vote to grant all of the relief by reason of our LUPA. That would be my view.
Same here.
I guess I'm as reluctant as the two of you are. And would be very tempted to write a dissent, but we'll choose not to. I will be with you.
Okay, all right. Well, I get that. I'm tempted to write a dissent for me. But right.
Okay.
Okay. All right. I guess we have a consensus then.
Yes. I believe we disposed of all the issues before us too.
Right.
Okay. Well,
Right.
thank you both, and I apologize for having misspoke on that first question, reading too
Okay.
quickly. Thank
Right.
you. All right.
Thank you. Yeah.
Thank you.
Thank you, Ms. Bernardi and Mr. Lauer. I appreciate it.
Thank you.
Everyone, this was a tough case.
It was very tough. Thank you. Bye-bye.
Thank you.
Yeah, bye-bye.
Be well. Go take Joey for a walk.
Bye-bye.
Bye-bye.